Good morning, everyone. Thank you for joining us today for a quick 30-minute webinar on what you need to know about technical assessments and New York City Local Law 144. My name is Chelsea, and I will be your webinar producer today. If this is your first webinar with us, then welcome. CodeSignal is the leading technical interview and assessment solution, helping the world go beyond the noise in technical recruiting with smarter questions, a simpler process, and a stronger platform. Before we dive into the details, let me provide you with a brief overview of what we will be covering today. As you know, New York City Local Law 144 is ushering in new regulatory guidelines around the use of automated employment decision tools when making employment decisions for New York City-based employers and employees. But what exactly does this require of employers, and how are automated employment decision tools defined? In this webinar, we'll be exploring these questions and more with our expert, Hayley Walton, CodeSignal's assessment research consultant. We'll also be discussing the responsibilities of employers and vendors such as CodeSignal and promoting compliance. We'll leave time at the end of the webinar to answer your questions, which can be submitted in the Q&A box throughout the webinar. If we do not have enough time to answer your question, we'll personally follow up with you after the webinar. Lastly, we will be sending out a recording of the webinar in the coming days. Without further ado, let's get started. Hayley, the floor is all yours.
Wonderful. Thank you for that intro, Chelsea. I'll kick us off with our agenda today. As Chelsea mentioned, we have a 30-minute session planned for you. So I'm going to walk through these 6 questions, but I'll try to leave some time at the end for question and answer. So the 6 questions we'll be addressing today include: what is New York City Local Law 144? What is an automated employment decision tool? What is a bias audit? What information should an automated employment decision tool notice contain? What are clients versus vendors responsible for? And how can CodeSignal help me with legal defensibility beyond even the scope of New York City Local Law 144? And as Chelsea mentioned, my background is as an assessment research consultant at CodeSignal, and I have a background in IO psychology. At CodeSignal, my team helps with the validation and science behind our assessments, as well as addressing questions for clients around things like this with legal defensibility and assessment-related strategy. So with that context, let's talk about the history of New York City Local Law 144, as well as the history of CodeSignal in this space. So CodeSignal has been around since about 2015, but along our journey, we began with building assessments. And in 2018, we launched the General Coding Framework, a breakthrough way to evaluate skills consistently and at scale while remaining EOC compliant. So while New York City Local Law 144 wasn't around at this time, some of the principles that lie behind it, like fairness, consistency, mitigating bias, were things that we were also thinking about. So after launching the General Coding Framework, we began to think about other ways that we could promote fairness, drive consistency and standardization. And in 2020, we began building our IO psychology team, also known as our assessment research team, to help drive the development of these fair and valid evaluations. At the same time, New York City Local Law 144 was being proposed and going through the initial drafting and development stages. In 2021, CodeSignal continued to develop our processes here and establish the Skills Evaluation Lab and introduce frameworks more formally into our product. Now, if you're a CodeSignal customer, you're probably very familiar with the phrase framework, but I will define it later at the end of this presentation for the rest of the audience. At the end of 2021, the Automated Employment Decision Tool legislation, also known as New York City Local Law 144, was passed in New York City. This was about December, so at the beginning of 2022, CodeSignal began partnering with external legal counsel to ensure that we would be compliant with ongoing legislation, as well as to further understand the ins and outs. At the same time, the Department of Consumer and Worker Protection in New York City was continuing to workshop the law and proposed a couple of different changes to the rules. These changes have not moved into effect yet, but they're something that I'll address and mention a couple times throughout this presentation. And also in 2022, there were public forums held so that participants could publicly comment on the verbiage of Local Law 144, as well as the proposed rule from the DCWP. So that brings us to 2023, where we are now. And in January 1st, New York City Local Law formally went into effect. However, it is not enforced until April 15th of this year. So as we move forward and we think about the current state and the future state, CodeSignal just wants to assure you that we will continue to partner with you all to ensure that you have everything you need to remain compliant with this law, as well as similar laws that might be proposed. So now that we have some context, let's move into the ins and outs of New York City Local Law 144. So this bill, proposed a couple years ago and becoming active on January 1st and enforceable on April 15th, aims to reduce the bias in the hiring process by increasing transparency around automated employment decision tools that utilize AI. And the concern here is that AI might sometimes incorporate potential discrimination in the hiring process. So the goal here is that employers and employment agencies that are using these tools will have to have more formal transparency requirements, essentially. So what are those requirements? First is that employers using automated employment decision tools will have to undergo an independent bias audit in the last year. Now, it is a little unclear with the current verbiage what is meant by independent auditor. And the proposed changes each define this a little bit differently. However, we will go into this a little bit further on what is required by a bias audit in a couple of slides. Secondly, it's also required that employers publicly display a summary of the results of the most recent bias audit and distribution data for the tool on the employer or employment agency's website. Third, employers must provide candidates with 10 business days of advance notice before the use of an automated employment decision tool. And employers must provide candidates with 10 days of notice regarding the job qualifications and characteristics that the tool will assess. So, as an example here, if an employer is using some sort of automated or artificial intelligence tool to assess the writing skills for a marketing role, for example, then the employer would need to explain what skills that tool is assessing and how it relates to the job qualifications. Fifth, the law also allows candidates to request an alternative selection process or accommodation. Now, I will say this does differ across the proposed rules from the DCWP. Some of the versions don't account for requesting an alternative, but given the current state, we're going to use the current language in Local Law 144 and interpret it in that way. And finally, employers are required to provide information on the type, source, and retention policy related to the data collected by the automated employment decision tool. So now that we have a better sense of what is required by the law, we're going to talk about who it applies to and when it goes into effect. So here we go. Who does this law apply to? The law applies to all New York City-based employers and employees. And those employees include candidates for employment as well as candidates for promotion. However, there is some ambiguity here around how employers will go about vetting these employees, meaning it may be difficult for employers to consider who is residing in New York City and how to identify those individuals. So that is something to consider as well if you are using an automated employment decision tool, especially in this remote environment. Next question is, when will it be enforced? So hopefully you've been paying attention and this is review for you, but the law is already in effect, but as it currently stands, it will not be enforced until April 15th, 2023. So we have just over a month until it is formally enforced. So now let's talk about the ins and outs of what an automated employment decision tool is, as defined by the law. So an automated employment decision tool, and this is a direct quote from the law, so I apologize for the legal jargon, is any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, including a score, classification, or recommendation that is used to substantially assist or replace discretionary decision-making for employment decisions. And in the case of this, employment decisions could be hiring or promotion. So something that is interesting about this definition is that the proposed rules from the Department of Consumer and Worker Protection actually differ a little bit on how they define this. But this initial language is actually kept generally pretty broad, actually. But however, that can leave some ambiguity. Something that I've learned from talking to other experts in the field is that artificial intelligence and technology can often be thought of as a spectrum of sorts. So some tools are really automated, other tools are maybe less so and involve more human review. So that's something to consider too in the interpretation of this law and similar laws. So because of the ambiguity of this language, particularly in the parts referring to substantially assist or replace discretionary decision-making, there may be some variability in how this could be interpreted. So some considerations to think about as you're evaluating your tools in your selection system could include, does the product you're using automate a score or recommendation? Is there human review involved? Are there other tools or predictors involved? And how are the decisions being made, or what conclusions are being drawn based on the tool? So all of these factors may change the answer of whether or not a tool is an automated employment decision tool as defined by New York City Local Law 144. So because of all of this spectrum and ambiguity, that's why it's important to discuss with the different vendors you're using and legal teams alike to ensure that you know what tools you're using, how they're being used, and how they fall along these spectrums. So that's part of the reason we're here today, to help you answer those questions in terms of CodeSignal. So the next question is CodeSignal an automated employment decision tool? So as the law is currently written, meaning the one that is currently in effect, CodeSignal is unlikely to be considered an automated employment decision tool, though we still recommend seeking legal advice and doing a little bit of an audit on your own tools so that you can understand for your other tools that you're using as well. However, we will note that given the ambiguity of the language here and the outstanding decision, we recommend that you continue to work with your legal counsel and or potentially an auditor to ensure that you're compliant. However, we will partner with you to help ensure that if language changes, so you understand how our products fit in and so that you can stay up to date. So with that in mind, let's move into the bias audit requirement. So say you're using an automated employment decision tool and you need to move forward with a bias audit. What does that mean? Once again, like the other things I've talked about, the ins and outs of this depend on the version of the text that you're looking at, and I base this entirely off of the original language of the bill. So according to the original language, employers must have an independent auditor assess whether the use of a tool results in disparate impact based on categories such as race, ethnicity, or sex. As of March 2023, the only explicit requirements are that the bias audit be conducted annually by an impartial third party, and a summary of the results should be published on the employer's website. Now, impartial is a little bit ambiguous in terms of if that's an internal employee or internal team, external team. And the other versions of the rules do go into depth and some detail about who this auditor might be. So some versions of the rules say that the auditor needs to be someone without a financial involvement or any sort of involvement with the development, but the original language does not specify this. Also, something that differs across the different versions is the type of analyses that need to be done. As it stands, the current analyses need to be disparate impact, which means looking at, from an IO lens, adverse impact across different groups. The most recent version of the DCWP requirements do look at this a little bit more in depth and consider things like intersectionality, but as it stands, this is not a formal requirement as of yet. It is worthwhile to note that the law does not provide detail on what the bias audit is supposed to examine specifically and how it accounts for different jobs or job classes, as well as how the findings are to be utilized or what a pass means for the bias audit. So those are some considerations to consider as you continue to consult with other vendors and your legal team. So now that we've covered a bias audit, let's start thinking about automated employment decision notices. Say you're using an automated employment decision tool, you've conducted your bias audit, you're fully compliant. Now what do you need to do? So the question is, what information should an automated employment decision tool notice contain? So employers who are using an automated employment decision tool are required to give candidates at least a 10-day advance notice. But what does that notice include? Some of the details that we've compiled, and this is based on the law, but also just best practices from IO psychology, include a notice date, employer or employment agency name, job position title, a brief explanation of the automated employment decision tool or tools if there are multiple, the purpose for which the automated employment decision tool system will be used, job qualifications and characteristics that the tool will evaluate, a right to request alternative or accommodation, as well as information on the data policy. Now, the bottom 4 or so are all explicitly listed in the law. However, I also included some other information that I think is helpful from IO psychology. So what we know from candidate experience research is that it's important to be transparent with candidates and to provide them with explanations and ensure that job selection methods are job relevant, which is also important for legality. When you treat these applicants with respect and include some of the recommendations here, they are backed by research, and it is most likely that candidates will have a more positive experience with your selection system. So while they might not be required by New York City local law, including things like job position title or an in-depth description of why you're using the tool, it can help promote that candidate experience and provide some empathy there as well. So now that we've outlined what an automated employment decision notice should contain, I want to talk through some of the different responsibilities. So this can be confusing. So we're going to talk about what the clients are responsible for, as well as what the vendors are responsible for. So first and foremost, what are the clients responsible for? So much to our clients' chagrin, a lot of the onus of this legislation does fall on their responsibility. So the user of the automated employment decision tool has a lot of responsibility with this legislation. So this means providing disclosure of the use of such tools, hiring an independent auditor to conduct a bias audit annually, publicly posting the results of a bias audit, providing candidates with 10 days advance notice about the use of a tool, as well as job qualifications and characteristics, and providing candidates information about the data policy. Those are all requirements of the clients. However, other vendors and CodeSignal ourselves are here to help and support our clients as they move forward to fulfill these compliance requirements. So we'll also outline how we can help and what we're responsible for. So as a vendor, CodeSignal is responsible for ensuring that our clients understand how CodeSignal aligns with New York City Local Law 144. We also want to partner to provide necessary data for any bias audits for candidates or roles that are located in New York City. So as I mentioned, there may be some ambiguity around what a bias audit requires. However, we are here to help partner if there are certain data requirements that you need from us. In addition, we can help provide employers information around the job qualifications and characteristics measured by an automated employment decision tool, and provide insight to alternatives to automated decision-making in the case that a candidate chooses to opt out. And finally, CodeSignal offers process documentation of how our processes work so that we can answer any questions should you choose to move forward with an audit. Now let's talk about how CodeSignal can help ensure legal defensibility for New York City Local Law 144 and beyond. Hopefully in the last 20 minutes or so, you've been able to gain some insight into how we already do this. But I also want to talk through other additional mechanisms that we can use to support our clients, as well as fit in with other ongoing legislation. And I will say this is coming from an IO lens and not a legal lens, but there are still some best practices in terms of facilitating legal defensibility through job relevance, consistency, standardization, and so on. So some of these offerings include local job analysis. If you're an existing customer, I assume that you may have heard about this before. It's something that my team is very passionate about. But a local job analysis, for those who don't know, involves looking at your roles to determine which content will best measure the core skills you need in your hire. It's a systematic process of looking at core job requirements in order to match knowledge, skills, abilities, and other characteristics to things like assessment and interview content. Some of the benefits include improving assessment and interview content, using it for training and development, updating job descriptions, leveraging it in performance appraisal systems, and more. It's also very important for legal defensibility. So job analysis and established job relevancy is going to become more and more important as we expand the use of technology and potentially AI in selection systems. It's also the foundation of all selection systems and HR processes. Secondly, we also offer local criteria and validation studies. These are another mechanism that can be used to help establish legal defensibility in accordance with EEOC guidelines and can help establish the link between performance on assessments and performance on the job. Third, skills evaluation frameworks. And this is something I mentioned at the very beginning of this presentation as something that is very much a pillar at CodeSignal, I'll say. If you're a customer, you've definitely heard us talk about skills evaluation frameworks, and it's something we're very proud of. But this is one of the best ways to build validation evidence and defensibility while also promoting fairness and mitigating bias. It's especially important as we work in the technical skills space, and it will prove to help promote legal defensibility as legislation continues to be developed. And then finally, I want to talk about local adverse impact analysis. So local adverse impact analysis looks at group differences in hiring across certain demographic groups, such as race, ethnicity, and gender. And this could be especially fitting for the requirements mentioned in New York City Local Law 144, but can also be really helpful in just understanding what your candidate pipeline looks like and how your processes might be affecting certain groups. So with all that being said, now we're going to move into the question and answer portion. I see that we have a couple of questions, but I'll kick it back over to Chelsea to help facilitate.
Thank you, Hayley. All right, so the first question I will pitch over back to you are what are some cases where the use of CodeSignal could be considered an AEDT?
Yeah, that's a great question. So I would say in the typical IO and legal jargon, it depends. And I would recommend working with your own internal team as well as legal counsel to ensure compliance. However, as this law stands, anything that's super automated where you're using a score without human review is at risk. However, I will say the exact definition of automated employment decision tool is going to differ across the different proposals. So it may change depending on what the final version is that goes into effect.
Thanks, Hayley. And the next question is, what is the obligation or responsibility of a staffing vendor supporting a client that requires the usage of an AEDT to assess any potential candidates before being submitted?
Can you repeat the question?
Yes. What is the obligation or responsibility of a staffing vendor supporting a client that requires the usage of an AEDT to assess any potential candidate before being submitted?
Yeah, so I think the question here is asking about potentially candidates who have not formally applied for a role. And there is ambiguity because the idea, I believe, in the current language is that they must have applied or have some formal way to vet that. So I don't think that that's clearly defined by the law yet.
Okay. And then do the bias audit results have to be published for just your company's sample or a broader sample?
So the law as it stands does not provide much guidance in terms of the data requirements. It just specifies that it needs to be publicly posted. So the answer, I think, would be best defined perhaps by a legal team, your own legal team's perspective on that. But I believe that local is usually the best.
Okay. And is a writing assignment seen as a tool as it pertains to this law?
I think that would depend on how that writing assignment is being reviewed and what level of automation is being used for that. So is it using machine learning to be reviewed, or is it reviewed by a human, and what level, is there a score being produced, or is it merely a recommendation that's being produced? And then how is the decision coming out of that recommendation?
Thanks, Hayley. So we have time for probably 2 more questions. So the next one I'm going to give over to you is, if a candidate opts out of an assessment test, can we disposition and reject?
I'm sorry, if a candidate opts out of assessment test. I think based on the current language, you would have to provide a alternative to the assessment test based on the current language. The proposed rules do have a little bit of a different take on this, but as it current stands, you have to provide an alternative.
Okay, and the last question is, why does CodeSignal not qualify as an AEDT if it leverages scores developed using data analysis, algorithm, etc.?
Yeah, that's a great question. So I think it depends largely on, well, of course, in the IO and legal terms, it depends, right? So I would highly recommend consulting with your own legal team and doing an internal audit on how you're using the tool as well. But I think it's just as a sweeping recommendation, there's so many different CodeSignal products and they can be implemented a lot of different ways. And so that's one of the reasons, right? And so as I talked about before, AI and technology in general is this really large spectrum. And so it's hard to make formal conclusions because they can be used so many different ways, right? And so that's the reason essentially that we have been advised. However, depending on how you are using it, there could always be some potential. And so that's why we recommend doing things like an internal audit and consulting with your own legal team additionally.
All right, thanks, Hayley. There were a ton of questions we weren't able to get to, a ton of great questions. So we'll be sure to follow up with everyone personally. There's also a related resources section as a part of the On24 console that links out to some of the FAQs that we've already received. We created a blog post that might cover some of these questions that have come through. However, we will follow up with everyone personally if we couldn't get to your question, and we'll be sending out a link to the recording in the coming days, hopefully by tomorrow. Everyone for joining us today, and a huge thank you to Hayley for your time and for the awesome presentation. We hope everyone has enjoyed, and this concludes today's webinar. So thanks everyone, have a good rest of your day.